right, welcome. Thanks for joining us this evening. It's great to have you here. And on a kind of rainy day in Juneau, I know some of you might be elsewhere as well. As I said, I'm going to talk for about 40 minutes or so with a presentation, and then I'll open it up for your questions. I'm going to introduce myself and then ask if there's anything you want to share about yourself and why you're here this evening. And then I'll cover what would happen to your stuff when you die, based on first what the state's plan is. So if you don't have a plan in place, you die what we call intestate without a will, then the state has a plan for you and it's going to kick in. And I'll cover that on a very broad level. And then we're going to talk about probate and what that means, if you've heard of it. If not, just hold on. And then we'll talk about some different planning tools you can use to really create something that's more fitting for you and that makes things easier for family. I'll cover some information about wills and when they're helpful, what a living trust is, when that can be helpful, and some other documents. I'll cover some incapacity planning tools. So if you could not make healthcare or business decisions for yourself, how do you make sure that the person you want to will be making those for you? I'll cover some different free tools available. I'll talk about when you might want to talk to a lawyer, and then I'll answer your questions. Again, I haven't introduced myself. My name is Liz Smith, and I am an attorney here in Juneau. My now husband and I moved here in 2005. For me, that was before law school. So I left, went out east to Vermont, and then returned for school. Or after school, excuse me. We knew that we wanted to make Juneau our home. And I spent about 8.5 years working for the state. When I graduated law school, I wanted nothing to do with private practice. And I clerked for Judge Pallenberg in Juneau for a year. And then I had decided in school that I really wanted to be a public defender, working in criminal defense. And when in 2012, I was the only attorney hired at the public defender's office, that was the start of budget cuts, but that position was up in Barrow, or Utqiagvik now. I spent 13 months up north at the start of my career, which was amazing way to start, really incredible experience. But my husband and our dog, our lab here in the upper right picture, they stayed in Juneau, making it more of a challenging experience for me. So when a position opened up in Juneau, I happily transferred, but I found that job in Juneau was with the public defender's office, but I was representing parents when the state takes custody of their children, child in need of aid cases, which was really a great work, but I didn't last very long. And went over to Department of Law, working in the civil division and representing part of Department of Health and Social Services, Senior and Disability Services. And that was okay for a while, but I had always had a dream of starting a business and had been terrified to do so. And then I also I would find that they would bring in the attorney when there was already a conflict, and I didn't want to work in conflict. And I also wanted to start working with individuals, with people. In 2017, while I was still working full-time with the state, I enrolled in the Institute for Integrative Nutrition, a certification program to be a health coach. And I started working with individuals on the side as a health coach and loved that interaction and that work. I really enjoyed helping people achieve health goals that they were struggling with and just get to know them on that deeper level. And so that was great. I thought that might turn into more. I wasn't quite sure what was next for me, but I decided that it was to leave the state after a very hard decision. I thought I might leave the law. I took some time figuring things out, deciding what to do, worked for a tourism company in town, and finally got up the courage to leap out on my own. As I was thinking about what to do, I knew I wanted to start a business and also have this law degree. And I started looking into working in estate planning, the wills and trusts, what I'm talking about today, and found a really amazing program called New Law Business Model, which is training attorneys to practice in a new way. And it was really appealing to me and has turned out, I kind of tried it at first, but it's been a really great fit. So I started Liz Smith Law over 2 years ago now. I love the work that I'm doing. Mostly right now, I'm just practicing in estate planning. I also work with some businesses and hope to plan to expand that practice, the side of the practice over time. And some of you'll hear about how we work at Liz Smith Law and some of what makes us unique, but just some of the highlights that I've found really rewarding. And I think it's great to see how they help individuals. So we really focus, the model that I follow focuses on people and not just your documents, right? You can go get a will really easily, but is that going to work for your family? So we get to build relationships the way we work. Help plan for the future instead of just responding to the future. Our office does almost entirely flat fee billing, so that and I mentioned earlier that when I started being an attorney, when I was licensed, I didn't want to do private practice. And a big part of that is that I had a really negative view of attorneys. I've worked with attorneys by the hour, and I have no idea if my question's going to take them a day of research, 8 hours at whatever their fee is, or a few minutes. And I just think that billing, it's annoying as an attorney. And part of that is I want to be able to have a nice conversation and talk about your family. And I'm not going to feel I can answer those questions if I have the clock running, and you're not going to want to answer those questions or ask anything about myself. So now you may be thinking, I know this is a hard topic, right? Talking about estate planning, talking about death, and you may be thinking, why am I here? Is this worth my time? And my goal as health coach and attorney is to help people take action that they wouldn't otherwise take, right? So this may be something that's been nagging on you for a while. I really should get this will in place. Or I have a will from 20 years ago. I should really update it. Now my kids are grown. And we want to help you move through the process and get something that you might be thinking about or have be stalled on, move through that. And we have systems in place to help make that happen. And some of the benefits that I love to see for when people do get these things in place and face their estate planning, face what's going to happen if they were to die sooner rather than later, is that it can help first bring the peace of mind, but then also it has some kind of amazing benefits for financial organization and even better family dynamics. If it opens up conversations, what a plan do your parents have? Are they set up? Maybe you're talking to your adult children about the plan that you've put together. People, I've seen some amazing things happen. Woo! All right, I guess enough about that. So that's some about us at Liz Smith Law. Just quickly, this is the little dog that I picked up when I was up in Barrow to keep me company. She's kind of a terror, but still with us. And I love to travel and triathlon, which of course, both I haven't been doing much of, but the picture of the bike, me on the bike, was my first Ironman. Okay, enough about me. Well, what about you? If you'd like to share something about yourself, we'd love to hear in the chat box. Again, you can make a note to everybody and share, or you can do a direct message if you'd like to myself, or at any time to Alex, my assistant, who's here with us this evening. All right, as you are thinking about doing that or doing it, I want to make clear that while I am an attorney, I'm not your attorney unless we have an assigned written engagement agreement. The information I'm providing here this evening is very general and not specific to your situation. So I will share how to get information specific to you, but just keep in mind it's not specific legal advice in terms of exactly what would happen in your situation. All right, why are you here this evening? Did you come to get the total assurance and comfort knowing that your family would be taken care of the way you want if something happens to you? Or maybe you came for the peace of mind, knowing what would happen to your assets at your death. Or maybe to find out how to make sure your family doesn't pay estate taxes unnecessarily. or maybe you came to make sure that you'd be taken care of in the best way possible if something happened to you and you were incapacitated. These are all great reasons to be here today. You'll learn what you need to do to have the peace of mind, knowing that you've made the right decisions for your family during your lifetime so that at your death, things are as easy as possible for the people that you love the most. So let's dive in and start first by talking about what the state's plan for you is if you die without a plan at all. And that plan is called probate. So probate is the process for any assets in your name at death. It is a court process. So this quote here, a lawsuit you file against yourself with your own money for the benefit of creditors, a bit tongue in cheek, but it shows how many people don't think very highly of probate. Now, if you don't have any plan, then someone has to come forward and they're going to petition the court, ask the court to be personal representative or executor, same thing. In statute, there are priorities of people to serve. So if you are married, it would be your spouse. If you're not married and have children and they're adults, they would have equal priority. If people have equal priority, like adult children, then if they can all decide who would serve, that person can fairly easily be appointed. If there might be a dispute about it, then they would each present that they wanted to be personal representative and why, and then the judge would decide who it would be. If there's someone else who wanted to serve, they could also petition. And if everyone agreed that you wanted someone, even if they're not priority per the statute, then they could also, that person could get appointed. So if everyone is on agreement, that's fairly easy. The priority comes into play if there's an argument about who would serve. So think about in your own family who might step in. Is it clear who that would be, or is it possibly that no one would step up, or they might be confused about who you would want, and there might be some conflict involved because of that. They may have to post a bond, and so there are some times where someone wants to serve but they can't. In the process, so the executor or personal representatives is appointed. Their role is to work with the court. There's different timelines, and they're going to decide whether they want to hire an attorney for help. And then they're going to gather essentially the assets. They have to prepare an inventory with a certain period of time. They have to publish. There's a lot of steps. It's a lot of administration, and they would be responsible for making sure all of that gets done. It's a pretty high level of responsibility to be personal representative. The entire process between filing in court and then getting to distribute the assets and close out the probate is typically 12 to 18 months realistically in Alaska. It is a public process, so anything that gets filed with the court, anybody can go and see who's going to inherit, what they're likely to inherit. At the courthouse, you can look at that file, and it can be expensive. So on this slide, there are some of the fees, attorney's fees, if they're used. That personal representative or executor has a right to be paid for their time. There may be other fees associated with appraising assets to decide what to split, how to split it up, paying off the creditors, and then filing with the court. If you die with minor children and don't have a plan in place, then the court, they cannot inherit. Or actually, let me just back up and talk about where the assets are going to go if you don't have a plan. If you are married, probably assets are going to go to your spouse unless you each have children from a prior relationship, or really if you have children that aren't related. Then it can get a little more dicey. If there are joint children and you're not, or not joint children, sorry. If you are single and have children, then assets would go to the children. If there aren't children, then parents and then siblings for the most part. That's where assets go. So if there are assets going to minor children, they cannot inherit until they're 18. And so a judge would appoint someone to manage the assets for them. The assets can be used, anything you've left behind, to care for them. And then when that child turns 18, they will receive everything that is left outright to do with what they want. Now, in or just quickly, I'm going to come back to this, but with a will does not avoid probate. I'll come back to that. But in Alaska, you can file something with the court that is a bit simpler than the full probate process if there are certain conditions met. So all three of these conditions would have to be met. First, if you do not own a house or any other real property, if the vehicles you own are worth $100,000 or less, and the entire value of your assets is $50,000 or less. Now, with that value of assets, it's the assets going through probate. So if you have a life insurance policy, retirement, types of assets that you've named a beneficiary, those flow to the beneficiary without going through probate. So they wouldn't be counted here as long as there's a valid adult beneficiary listed. So this, you're probably thinking the value of assets would be bank accounts, boats are not considered vehicles, jewelry, things like that. So if all three of these conditions are met, then the process is a bit easier. It's quicker, it's cheaper. You're not looking at full-blown probate. If you don't want to be stuck, or you don't want your family to be stuck, because really we're talking about what your family has to deal with. If you don't want your family to be stuck in the probate process, a will does not avoid probate. A fully funded living trust does avoid probate. And we'll come back to some of the reasons what a will does and doesn't do, and same with a trust. So quickly, what about estate taxes? I should probably make this 2 minutes these days, and you'll hear why. But you may have heard of estate tax. It is a federal tax. There is no Alaska state tax, and it is a tax on any of your assets after you die. Now, there is, I'm not going to get into the marital exemption, but so the value of the assets upon death. You only pay the tax, any assets over whatever the exemption amount is at the time of death. That exemption amount varies over time. It's a political number. Lately, it's been 3 to 5 million for quite a while. The last administration bumped it up to over $11 million. So very few people are paying estate tax these days. It's not something that most of my clients are planning around, but it's good to monitor, especially if you're married and one spouse dies and the survivor inherits everything without thinking about it. They could be looking at an estate tax problem. Maybe not today, but when the estate tax level comes down. And your estate for estate tax purposes is any of your assets like you see listed here. And what I'm trying to point out is that the real property is only going to be the equity value, and then life insurance and retirement that might not be a part of your probate estate, meaning and they might not go through probate, they're still going to be considered for estate tax purposes. All right, so what about a will and a living trust? Let's talk about some planning tools if you don't want to be your family to be dealing with the state's plan for you. So a will keeps your family out of conflict. You decide who is going to be the personal representative. You decide where your assets are going to go. One thing I like to make sure you're thinking about is if you wanted to give anything to charity, that will never happen unless you have a planning document in place. And you're deciding, well, you're making decisions to keep your family out of conflict. You have control for the same reasons. You get to decide what you want to happen. You can have some control over how assets are going to be inherited and when by different people. You can decide that you want a specific asset to go to a certain person, which would never happen under the state's plan. A will is perfect if you're not going to face probate anyway, based on your assets, right? You don't own real property, those three categories I went through. Could face probate. You name guardians for minor children in a will. And that's really nominating who you would want to care for your minor children if you don't live to see them reach adulthood. Okay, so what about a living trust? A living trust is an agreement, to simplify it. It's an agreement and somewhat of an entity. The trust owns your assets. So that upon death, remember I said probate is for any assets in your name, but if the asset is in the name of your trust, then it's going to pass to your beneficiaries without going through the court process. So it keeps your family out of conflict and out of court. You have even more control. Especially one thing I like about trusts is if for a couple, they can keep all their assets together, whereas a will is going to deal with just your share. That was somewhat simplified, but just know that there's more, some more flexibility. You can ensure that your children do not inherit outright at 18. We could also do that with a will. There are some more you can do if you start with a living trust. So you could decide you want 50, you could even give 50% at 18, but then want to keep some until they're 35 in a trust. Or you can keep assets, whatever you want to do, you can do it. Then you can also limit distribution. So if you want to give assets to someone that you know is not going to, or worry might not handle them well, you can give to them in a trust and then name someone else to manage the asset. So to use a really personal example, my mother was an only child, and she got involved in drugs and alcohol when she was in high school, barely graduated high school. And she was able to keep a job while her parents were living, but then they passed away. I was in first grade at the time, and she inherited everything. And she took that inheritance and sold their nice house in California, moved to Oregon where things were cheaper, and was able to buy a house and some property, and then live off the inheritance for, she managed 14 years, but she was in extreme debt at the end of that. Didn't work. It was a really bad situation with drugs and alcohol. And so what her parents could have done, they knew that she wasn't, that she was involved in drugs. It was the inheritance that allowed her not to work, right? And so I don't know what they would have wanted to do, but what they could have done is put those everything into a trust, and they could have had as much control for the trustee as they wanted. So if they had a friend to manage the, invest the assets, they could have said, well, that person, you can limit distribution. So if, you know, you think that she's using, you can say, nope, you can't have any money from your trust. Or if you don't have a job, you can't have any money from your trust. So you can put restrictions on any kind of restrictions you want on trust assets. The beneficiary doesn't actually own them, and you're just deciding the control. So when and how they get them. I'm kind of fumbling that a little bit, or I think not making it that easy to understand, but I think you could get the gist that if you want to put control or just some extra protections around an inheritance, you can do that. You can also provide asset protection by giving assets in a trust. So they can be, you don't get asset protection when you create your own living trust, but if you give assets to your children or other loved ones, or even your spouse in a trust, you can protect those assets from their creditors. All right. If you have minor children, one other thing to think about is what happens in the short term. My mentor was starting out in her estate planning career, and she had her will in place, and her will was tucked away, protected somewhere. And she went out, she had 2 young children, was out to dinner with her husband. And she started thinking, well, what if we're in a car accident on our way home? They might live, but they might be in the hospital. So they don't come home. And what's the babysitter gonna do? She'll probably call the police. She would call the police. And the police may have no choice. They probably wouldn't. They're going to put the children in foster care while they get things figured out. It's going to take some time for the guardians she had named, her family, to get out to where the kids were. They were in a different state. So what she just started really thinking, what's this scenario, right? And even if the people that her kids knew eventually got there, it'd be an extra trauma for them to be with the care of strangers. And so she has developed something that we use in our office, which is appointing temporary guardians, so that you're creating a legal document that can tell the police, hey, here are the people that I want to care for my children if something happens to me in the short term. You're not naming long-term guardians. You're just saying, look, if they need someone to step in for a period of time, here's some people that I trust and that know my children to take care of them. A couple other things to think about as we talk about estate planning is one is community property, which is very complex, but just know that if you are a married couple and you have highly appreciated assets, then there are ways to, if one spouse dies and the survivor decides to sell that asset, that they can, they wouldn't pay capital gains tax if that asset, if that is owned as community property. So again, it gets really complicated. Just know if you're married and you have to take action to own an asset as community property. It's something very rare, but that you can do in Alaska to choose to own as community property. So just talk to myself or someone else or your accountant if you're in that boat about whether it makes sense to you to own something as community property. What about long-term care? If you are thinking about what would happen if you had to be in a nursing home, or maybe you have parents in that scenario, there are ways to make sure if there's a possibility that you might run out of assets before very quickly. So I just heard that in Alaska, the nursing home average fee is over $30,000 a month. Nuts. So you could have a lot and it could go really quickly. And there are ways to ensure that those assets are going to last longer. But you can get Medicaid to pay for the nursing home care sooner. So again, just putting that out there that that's a good, reach out to us or somebody else if you want to learn more. And Alex just shared in the chat box the link to the Kids Protection Plan. When I was talking about minor children and short-term guardians, we have a great website where you can name your own guardians and find out some more information. So what about incapacity? If you were in a coma for a period of time, we've seen people in the hospital with COVID who are unable to make decisions for a period of time, or maybe dementia, which kicks in, might be kicking in for the rest of your life. Who is going to make decisions and what decisions are they going to make? So we think about business decisions as power of attorney, and that's thinking about banking, finances, and then healthcare decisions. So what kind of care are you going to receive? When, how much life support do you want? Do you want to be on continuing life support if doctors don't think you're going to improve? Those kinds of decisions. And so I used to think very in terms of making these decisions. Well, of course you want to decide who, right? Because otherwise anybody could be step forward to be guardian, or not maybe anybody, but maybe not the people you want to make those decisions, right? But then the other aspect of it is that if you don't get something in place, power of attorney and healthcare, we call it a healthcare durable power of attorney. There's a lot of different names for these documents. But if you don't decide who you want to make healthcare decisions for you, and you can not make them yourself, then someone will have to go to the court and ask to be the guardian or conservator, which manages the money. And that process means waiting for a court hearing. So I was recently involved in a guardianship matter that was high priority, and we couldn't get a court hearing for over a month and a half. And then it can cost money dealing with court, especially if you want an attorney's help. It's obviously more time consuming, preparing for court, waiting for court. And then when someone's appointed as guardian, they have to deal with the court constantly. So I met someone recently. I was traveling to give a presentation, and I was talking to someone in the hotel about what I was there for, and she had just gone through that, where her mother had a stroke and they had her brother appointed as the guardian to make decisions for her. Now, mom probably would have wanted the son. That probably wasn't the issue, but they had to deal with the court now because she didn't take some time. And I'm about to show you how easy it is to make these nominations yourself very, very easily. All right. So Alex will share these links as well. The first is an advance directive. So Alaska has two statutory forms, one for healthcare decisions, one for business decisions, and those links are shared here with you. So you can, if you don't already have these documents in place, go print them out. You'll need a notary. You can work through them, just get something in place. There's lots of ways, and here's a link for 5 wishes. There's lots of different types of healthcare documents that are legal, and you can provide more information about your wishes to, if you want to do that. And I have other ones, but right now it's just get something in place. And of course, we'll work with you. And all of the plans we have, if you end up working with us, are going to include these documents as well. But if you're not taking that step, then here's another step. All right. Here's the requirements for a will, which I'm not going to spend a lot of time on. All right. So now nearing the end, but just thinking about if you had to choose between the people you love receiving your money or your values, insights, stories, and experiences, what would you choose? And of course, you don't have to, but I just like to point out that as we think about and talk about assets at death, what about your intangibles, right? It might be more important that you're sharing some of your stories and leave those behind. My grandfather wrote a story, life story. I think he took a class late in life, and that has been so amazingly valuable. He passed away just before the pandemic started at 100 years old, and it is so nice now to have his stories that I didn't listen to when he would tell me, and so I'm really glad to have them written down. That's something you can do. There's lots of different story capturing programs out there. You could look up Storyworth. And then we record legacy interviews with our clients. At the end, or as part of our planning, we do a legacy interview to share some of your stories. We have some great interview questions. A really neat part of the process. So I'd like to talk about when you might, how to maybe think about working with a lawyer or not. Now, of course, I'm somewhat biased because I would love to work with you, but I also see in my work just how complicated this can be. I just heard a story recently. A colleague talked to someone who's knew someone. Well, I mean, we share a lot of these stories, right? So it might not happen a lot, but it could, that someone did their will online and she ended up disinheriting her children and had died, and they were dealing with that. So as a friend of mine said, a colleague as well, a different attorney, when he was out fishing with his son, he doesn't live in Alaska, but he realized that the line was all messed up, right? He clearly didn't do it right, and was thinking about, with estate planning, you don't know. He knew then he wasn't wasn't fishing right. But with your estate plan, it either works or doesn't, but it's after you pass. So with that, with an attorney, you have the added assurance that the people you love stay out of court and out of conflict if that's important to you. If you want the people you love to have someone to turn to when something happens to you to help guide them through the process, I do family meetings, and I think many attorneys do as well, where we meet with your children and you, if you want, or someone else who's going to carry out your plan, and start developing that relationship. I mentioned my grandfather passed recently, and my aunt had met with his attorney, or my grandparents' attorney, over time. And when she was grieving, it was really helpful for her to have some trust built up. Sometimes it's easier to hire someone if you're thought about it, been planning, had the forms you're going to fill out and haven't done them yet. Maybe it's time to just get it done. And then there's a lot of complications if you are creating a trust. Remember that I said it has to be fully funded to work properly. That means the assets have to be in the trust, and that is phenomenally complicated, not to mention how you're setting up the trust document. So I would recommend, if you want to trust, if you're going to make things easier for your family, then make them actually easier and do it right. Unmarried couples, there's things get a little more complicated, blended families. There's some amazing planning you can do that's a little more complicated, any unique situations. And with that, there's some great resources on the court's website that you can check out, and we'll put that link in the chat box as well. And then Alaska Legal Services also has some good resources. The Juneau Public Libraries as well. If you've ever watched one of their presentations, they do them quarterly, I think. They have some free resources for you as well. All right, so I've covered a lot about the could have, should have, what could happen. And take a moment to consider, or I'd ask you to take a moment to consider what's most important to you. Possibly you are put at ease because you're comfortable with what would happen. Or maybe you think, oh, I'd really like to explore what it means to provide asset protection for my children. Or maybe you want to make sure you're deciding how and when your children inherit and taking control over that. Or maybe you want to avoid probate, whether that's because of the time it takes or the cost of it, or maybe you want privacy for your family. So I'd invite you to think about what the next step is. You took a first step getting educated here today, but keep the momentum up. So if you're thinking, oh no, what would happen to in my particular situation? Would my family end up in court? Could assets potentially be lost if you're not organized and your family doesn't track them down through the probate process? I'd love to give you the opportunity to get answers particular to your situation. And that's a life and legacy planning session with me. It's a 2-hour working session that can be done either here in Juneau in person or virtually. I'm also traveling to Haines. If anyone is in Haines, I have been going there fairly regularly, and I'll be there early October. And we sit during that life and legacy planning session, we sit down one-on-one and look at what you have. And then you share your family dynamics, and I tell you about the law. And then we look together at what would really happen to the people you love if something happens to you. And then you tell me what about that works for you and what doesn't. And then together we choose the estate plan that will be best for your family from a cost perspective and an outcome perspective. So even if you think you're comfortable with what would happen, I invite you to take that next step to get the peace of mind, knowing that you're comfortable with what would happen with your family. So normally that 2-hour meeting costs $750, but because it's that 2-hour working meeting, but because you're here and taking the step of getting educated, and if you agreed to do some homework before that meeting to make it a really effective working meeting, which is that homework is gathering information about your assets, which is important anyway as part of any planning process to make sure your family can find what you have if something happens to you. So if you do the homework, I'm happy to offer that meeting for free for anybody here. And then remember I said that my goal is to make this as easy for you as possible and to make sure you get it done. And so to that end, if you would like to schedule that meeting, and if you book your appointment this evening, then I will give $250 off of any plan that you choose if you go ahead and work with us. So you get the free meeting valued at $750, and then an additional $250 towards any plan that you choose if we work together. So all you have to do to book that meeting this evening is go to this lovely link, which Alex will shortly post. And you should have that in your inbox probably about now as well. And you can book, schedule a time that works for you, a 2-hour block. I do recommend that you give yourself some time. So I'd recommend you book out at least a couple weeks. And I know I'm going to be gone a lot in October, so it might be dicey, but I know we still have some appointments left. And that's to give yourself time to do the homework. So I'm about to tell you how you get the homework and how that works. But now you can just find a time that works. And then If you are planning with somebody else and you don't have time to talk to them about their schedules, you're welcome to change one time and we're still going to give you that $250 off. So if you have to talk to them, and you can also book that out as far as you'd like, based on your schedule. Now, if you have any questions about whether that's important for you to do right now, of course, I'm going to open it up for your questions in just a moment. And you can also do it later for sure. I'm happy to offer that Life and Legacy to you for free for coming here. You just won't get that $250 off additionally. All right. Now, I love to talk about what it's like. Oh, virtual in person, what it's like to work with our office, just to give you a sense of what the process is. And I hate to say it, but I know some people do get intimidated by attorneys. And so I know that when I'm going into something new, sometimes it's helpful to have an idea of what's coming. So work with us, what you can book your appointment now online, and then we're going to reach out. If we don't already have your address, we'll need that because we want to send you an introductory packet in the mail. Oh, someone is somehow managing to write on the, I'm not going to worry right now. All right. So then we send the introductory packet in the mail. And then you fill out your, okay, we'll get your address so we can send that, and we'll call with some other questions. And then you'll fill out your Life and Legacy inventory and assessment. So that's a form that you can do online. And then you can also, we also mail it to you if you want to do it by in paper. So and that's some information about your family. That's what we call the homework, the inventory and assessment, and then some information about assets. And that's so that we can understand what would happen to your family if something happened to you. Then you're going to gather documents from deeds, account statements, any current documents you have now, like a current will or trust. We would need that before your meeting. These documents, if you're coming in person, it's just helpful to bring them because if we work together, we'll need them. And then we have your Life and Legacy planning session to get clear on what would happen to the people you love and your assets when you die. And you choose if you want to create a different plan or not. If you decide you want something different and you decide there's a good fit between yourself and the firm, then we would design your plan during that 2-hour meeting. Usually we have enough time to design. Sometimes we need to carry over into another meeting. But once your plan is designed, that means where assets are going to who, then you're going to sign documents about 4 weeks later. And so after you sign everything, we hold on to it to scan, and then we do another binder delivery meeting. And in between those, we can do the legacy interview that I mentioned earlier. Now, really, really importantly, and if you have a plan in place or you work with anybody else, we do a free review at least every 3 years, and you should be doing that with anybody so that you're just making sure your plan stays up to date with the law. So no, without you taking action to at least meet with myself or another attorney, we're not going to catch if your plan runs stale and the law's changed and you really want something else. We work with a number of legal insurance plans for payment from ASEA, APEA, and others you see here. There are many. And with that, I do a webinar usually once a month. If you enjoyed this, I'd love your feedback, good or bad. And if you think someone else should see it, send them over to lizsmithlaw.com/events, and they can find our most recent one. Or if you receive our newsletter every week, we keep that up to date as well. All right, thank you. I am going to stop this and open it up for questions. You're welcome to unmute yourself. I'll stop.